Good day, everyone. This is Dr. Soper here, and today I'll be discussing the 12th and final topic in our series of lessons on information privacy and security, with today's topic focusing on information privacy. The information age has caused some of the rapidest and most alarming changes to personal privacy ever before witnessed in the history of mankind. Organizations and governments of all kinds are asking for and collecting more private or sensitive information about people than ever before. Further, most people are now sharing or are willing to share more private details about themselves, their lives, and their preferences than ever before. In fact, sharing private information has become such a common activity that many people now freely share highly sensitive information about themselves without ever considering the consequences. The gathering and sharing of private information has become so widespread that the information age, despite all of its benefits, must be looked upon as having been absolutely disastrous from the perspective of protecting one's personal privacy. In order to better understand the rapid collapse of information privacy since the dawn of the information age, we must become familiar with the three major facets of information security. The first of these facets is disclosure control, which refers to the extent to which a person can exercise control over the disclosure or sharing of her own private information. The second facet of information privacy is data sensitivity, which refers to the extent to which information is sensitive within a particular context. Note that the extent to which information can be considered sensitive is often a matter of perspective. After all, one man's trash is another man's treasure. The third major facet of information security is the affected party, which refers to the party or parties that would be negatively impacted if private information were to be disclosed. Note that a party in this sense might be a person, a group, an organization, a government, or any combination thereof. The widespread adoption of information and communication technologies, or ICTs, has created several critical and serious threats to information privacy. The first of these threats is data collection. Information and communication technologies allow massive amounts of potentially private data to be collected, shared, and analyzed. The second critical threat is lack of informed consent. Potentially private information about the actions or preferences of specific individuals is routinely collected without the explicit consent of the individuals themselves. Examples of the types of information that are commonly collected without explicit informed consent include web searches, product preferences, IP addresses, location information, and so forth. The third major threat related to the widespread adoption of ICTs is loss of control. In the information age, potentially private or sensitive information is commonly sold or shared between business partners. Individuals typically have little knowledge of or control over such exchanges. Many companies, for example, commonly share or sell individuals' mailing addresses, product preferences, email addresses, and so forth, without informing those individuals or obtaining their permission. The final critical threat to information privacy relates to the ownership of private or sensitive data. For example, if a company is sharing or selling your private data, should you get a share of the profits? Further, consider that after you have shared your private data, the person or organization with whom you have shared your data may not protect it sufficiently well, or may divulge your personal data to other parties without your knowledge or consent. As a means of constraining the abuse of individuals' private data, several principles should be used to guide the collection of potentially sensitive information. The first of these is the principle of limited collection. Information should only be obtained in a fair and lawful manner. Second is the principle of data quality. Information should be of high quality and should be relevant to the context for which it is being gathered. Third is the principle of purpose specification. The purpose for which information will be used should be clearly specified, and the information should be permanently destroyed after that purpose has been achieved. Fourth is the principle of limited use. Information should be used only for a specified purpose unless the individual explicitly consents to it being used otherwise, or the law requires it to be used otherwise. Fifth is the principle of safeguarding security. Procedures must be established to protect sensitive information from being lost, damaged, or misused. Sixth is the principle of openness. Information about the acquisition, storage, and use of personal information should be easily obtainable. Seventh is the principle of individual participation. Individuals should have the right to examine, challenge, and correct information about themselves, their lives, or their preferences. The eighth and final principle is the principle of accountability. Organizations and governments must monitor the extent to which they adhere to all of these principles, and must be held accountable for violating these principles. Clearly, many of the information collection principles described above are commonly overlooked or entirely ignored by modern organizations and governments alike. One of the greatest challenges associated with information privacy in the information age relates to the law. Put simply, privacy laws vary from country to country. This situation is problematical because in the information age, private data can easily cross geographic or political boundaries. In the United States, for example, the Privacy Act regulates how data are collected by the government. The Privacy Act ostensibly applies to all personal data about an individual held anywhere in the government. Additional laws regulate the collection and maintenance of personal data by other organizations in the United States. Unfortunately, these laws are inconsistent and typically apply to only one target domain. Examples of such laws are the Fair Credit Reporting Act, the Health Insurance Portability and Accountability Act, the Federal Educational Rights and Privacy Act, and so forth. With respect to privacy laws outside of the United States, the EU's European Privacy Directive requires that both governments and organizations operating within the European Union maintain privacy rights when collecting and using data about individuals. This directive also largely requires that governments and organizations adhere to the 8 information collection principles described previously. Other information-driven societies, such as Canada, Australia, and Japan, have also instituted laws that regulate the collection and protection of personal data relating to their citizens. Many people do not realize that in the United States, government websites are required by law to address 5 specific factors relating to privacy, namely choice, notice, security, access, and enforcement. With respect to choice, individuals using government websites must be given the option to choose whether to provide personal information, and if so, must be able to choose how those data will be used. With respect to notice, the data collection practices used by a government website must be disclosed to individuals before the website collects their personal information. With respect to security, private information that is collected from individuals via a government website must be secured against unauthorized use. With respect to access, individuals who have provided private information via a government website must be able to view, evaluate, and contest the accuracy of the data that has been collected about them. Finally, with respect to enforcement, a government agency whose website fails to comply with established information practices will be subject to sanctions. Beyond addressing the 5 information privacy factors described above, government websites in the United States which collect potentially private information are also required to provide privacy policies related to the collection of such information. Corporate and other non-governmental websites in the United States are not bound by the same privacy standards which govern the collection and use of private information on government websites. To assuage public concerns, many companies and other non-governmental organizations make privacy policies available on their websites which detail the way in which personal information is collected and how that personal information will be used and shared by the organization. Such privacy policies are not, however, required by law. In the United States, the Federal Trade Commission has the authority to pursue legal action against a website that violates or does not otherwise uphold the tenets set forth in its privacy policy. It is critical to note, however, that these policies are typically unregulated, and as such, organizations can include essentially whatever terms or conditions they desire in their privacy policies. With this in mind, it is perhaps not surprising that most privacy policies heavily favor the organization rather than the individual who is using the organization's website. Further, many organizations state that the usage of their websites signifies that the user has read and agreed to the terms of their privacy policies. This devious strategy is effectively a license for these organizations to collect, store, use, or share personal information relating to their users in whatever way they like. As a final irony, it is important to understand that a website can only be sued for violating its privacy policy if it has actually established a privacy policy. Since establishing and posting a privacy policy is not legally required, an organization in the United States can protect itself from lawsuits simply by choosing to not formally post a privacy policy on its website. Given the inconsistent patchwork of laws and privacy regulations across the globe, individuals must remain vigilant and intentionally act on their own behalf to protect their private data. An obvious way of protecting one's private data is through anonymity. Put another way, an individual who is concerned about privacy issues may take steps to participate in activities anonymously. On the internet, anonymity can reduce discrimination and allow individuals to explore private or socially questionable interests without fear of embarrassment or persecution. Unfortunately, both governments and companies have been working diligently to make anonymous participation in online activities increasingly difficult. Another way of protecting one's private data is through the use of multiple identities. On the internet, it is often easy for individuals to create multiple identities for the purpose of preserving privacy. This may be as simple as creating a game character or multiple avatars, or as complicated as creating multiple digital personalities, each with his or her own unique characteristics. Since it is individuals who must intentionally act on their own behalf to protect their private data, it is important to realize that on the internet, an individual's private information is essentially a digital representation of that individual. Put another way, a website typically does not distinguish between your personal information and you as a real, living, and breathing human being. As such, possessing your personal information is often sufficient to allow a malicious party to masquerade as you with respect to online activities. Unfortunately, comparatively little personal information is needed in order for someone to effectively steal your identity. In the United States, for example, a mailing address, social security number, and birth date are typically all that is required to fully assume the identity of another person. This fact is particularly disturbing if you consider how little time and how little space are actually required in order to convey and store this information. The rapidly expanding collection, storage, and analysis of individuals' personal information by governments around the world presents serious implications for individual privacy. Consider, for example, that virtually all of the documents that a person uses to establish her identity are issued by a government. The various unique numbers and codes that governments use to identify individuals, such as social security numbers, driver's license numbers, and so forth, are often the same numbers and codes that other organizations use for the purpose of identifying individuals. Because of this, both governments and organizations can easily link together information about you that has been gathered from multiple sources in order to produce a detailed profile of you as an individual. It is also important to realize that governments now commonly acquire data about their citizens from organizations and other non-governmental sources. Because this information is used by governments to build detailed profiles of individual citizens, citizens must be concerned with the accuracy, integrity, and quality of the information about them that organizations are providing or selling to the government. Consider, for example, how many perfectly innocent citizens have been harassed, embarrassed, or detained at airports simply because their names are similar to those on a terror watch list. In the modern era, the concepts of authentication and privacy are intimately linked with one another. To better understand why, consider first that the process of authentication can apply to an individual, an identity, or an attribute. Authentication of an individual refers to the process of authenticating a genuine physical human being. This can be a difficult task, since the identity of a physical human being is typically established solely through documentation, records, or personal acquaintances, all of which can be manipulated. Authentication of an identity is, by contrast, the process of authenticating a set of credentials. Each real, physical human being has many different identities, and each of these identities may be authenticated in a different way. Finally, authentication of an attribute refers to the process of authenticating a characteristic of a person or other entity. Collecting data about a sufficient number of attributes or characteristics can allow a physical human being to be identified with a high degree of confidence. Consider, for example, the people in your family. If someone were to collect several attributes about each member of your family, say each person's age, gender, height, favorite food, favorite color, and information about any tattoos or scars, would it be possible to identify each person individually? Hopefully, this example serves to illustrate the connection between authentication and personal privacy. As organizations and governments progressively adopt data mining and analytics, privacy concerns associated with these activities are becoming increasingly visible and relevant. Data mining and analytics allow patterns, trends, and relationships to be extracted from individual data values. The correlations or aggregated results produced from these processes may be innocuous, but if the individual data values from which those results are produced contain private information, then privacy issues must be considered. This may be especially problematical when data mining or analytics operations are outsourced to a third-party organization. Data mining and analytics may be particularly disconcerting from a privacy perspective when it is the government that is engaging in these activities. Whereas courts of law, bad publicity, and other forms of oversight can help to ensure that non-governmental organizations protect privacy when engaging in data mining or analytics, government data mining and analytics activities may be performed secretly or without transparency or legal oversight in the name of national security. For this reason, data mining and analytics activities are particularly troubling to many citizens and civil rights groups. Since data mining and analytics threaten personal privacy, we must seek to develop and implement methods that can protect privacy while still allowing the benefits of data mining and analytics to be realized. Note that simply removing identifiers, such as social security numbers or driver's license numbers, from a database is insufficient to protect privacy because individual human beings can often be easily identified using the values of other attributes. Correlational analyses form the quantitative foundation of many data mining and analytics techniques. Correlation-based analyses seek to identify and quantify the strength of relationships among variables in a database. Unfortunately, no perfectly effective method of preserving privacy for correlational analyses currently exists. One proposed method seeks to protect privacy by randomly swapping private data values, thereby introducing uncertainty into the database. Although it may help to protect personal privacy, such a strategy must be carefully implemented so as to avoid introducing an unnecessarily large degree of new quantitative error into the database. Aside from correlational analyses, aggregation methods also provide a quantitative foundation for many data mining and analytics techniques. Aggregation-based analyses seek to identify trends and patterns in data through the computation of summary statistics such as sums, frequency counts, averages, and so forth. The likelihood of a personal privacy breach in the context of aggregation-based analyses can be dramatically reduced simply by using large data sets. Privacy with these types of analyses can also be somewhat protected by adding random error values to the individual data items, which together comprise the data set. For many people, the Internet now represents the single greatest threat to personal privacy. Once private information has been divulged via the Internet, information and communication technologies allow that information to be shared, copied, analyzed, and widely distributed without the divulger's knowledge or consent. Internet-based threats to privacy abound in the modern era and include such activities as social networking, online payments, website registrations, preference tracking, targeted advertising, contests, prizes, special offers, cookies, spyware, adware, and many more. The rise of social networking has led directly to a massive erosion of personal privacy, the scope of which has no parallel in human history. Most people who use social networking sites believe that the primary purpose of such sites is to allow them to connect and share information with friends, family, and colleagues. Although social networking sites do indeed provide such capabilities, these activities are not the primary purpose of social networking sites. On the contrary, the primary purpose of social networking sites is to gather, store, and analyze as much private information about their users as possible for the purpose of generating corporate revenue. Not only do users of a social networking site provide its underlying corporation with information about their preferences through the mechanism of liking something, but they also provide the corporation with much additional private information, including age, gender, relationship status, occupation, place of birth, educational history, family members, who the user knows, what the user likes, and even where the user is located at that moment in time. Truly, users of social networking sites are providing their underlying corporations with more private information about themselves than is known by their governments, their employers, or even their closest family and friends. Another notable threat to personal privacy exists in the form of online payments, which might utilize credit cards or other online payment systems. To purchase goods or services online, consumers commonly provide their credit card details to the owner of a website. Implicit in this transaction is the consumer's trust that the website owner will protect and not share or otherwise misuse their credit card information. Consumers should carefully consider whether this trust is truly warranted. To avoid providing private credit card details to many different websites, consumers may opt to use an online payment system such as PayPal. Although such systems help to protect privacy in several important ways, they are also a threat to privacy insofar as online payment companies are not subject to the same oversight and regulatory mechanisms as traditional banks or other financial companies. With respect to website registrations, nearly every time that a web user registers with a new website, she must supply at least some personal information about herself, such as her name, address, phone number, email address, birth date, and so forth. Websites, of course, may use this information for advertising purposes, data mining, or may simply sell it to the highest bidder. Many websites are increasingly asking for very private information in order to allow lost or forgotten passwords to be retrieved, examples of which include the user's city of birth, her mother's maiden name, etc. This is often the same information used by banks or government organizations to identify citizens. Consumers should carefully consider whether for-profit websites should also have this information. With respect to preference tracking, many websites are now tracking user actions to indirectly collect private information or infer user preferences. The increasingly common like mechanism being used by many websites is also designed to track user preferences. Consider, for example, what a company such as Amazon.com could infer about a person who searches extensively for books about infertility or a specific sexually transmitted disease. Alternatively, consider what a company like Facebook.com could infer about a user who likes many books or movies about people such as Joseph Stalin or Adolf Hitler. Targeted advertising also represents a serious threat to personal privacy. Contextually relevant ads have proliferated on the internet. Such ads may be a privacy concern because the company providing the ads collects information that could potentially be used to identify the person who has clicked on the ad. For example, IP addresses, geographic locations, subnets, affiliated organizations, connection speed, etc. Further, the site to which the user is directed after clicking on an ad may request that the user share private information, thus eroding her privacy. Since the dawn of the internet, malicious parties have been using prizes, contests, and other special offers for the purpose of tricking people into divulging private information. For decades, the excitement of a contest or the promise of money, discounts, prizes, or other rewards has led countless people to divulge highly sensitive information such as bank account numbers, social security numbers, and so forth. Perhaps the best known and longest lived example of such activities is the infamous Nigerian bank scam, which has been clogging email inboxes since the 1980s. Cookies also represent an internet-based threat to privacy. By design, the internet is largely an anonymous realm. Under normal circumstances, for example, a website would be entirely unaware of the other websites that a user has recently visited. Tracking cookies, however, are commonly used to defeat this anonymity. A number of different websites, for example, might opt to participate in the same tracking cookie program. As a web user navigates from one participating website to the next, cookies are used to track and record her actions, which can then be intermittently transmitted and stored. All of the participating websites may then be granted access to the user's preference data, or the data may be sold to third-party companies who may use it for purposes of targeted advertising. Finally, internet technologies provide a conduit for the rapid dissemination of spyware and adware programs and mobile apps. Spyware may clandestinely search a user's computing device for sensitive or private information such as credit card numbers, passwords, email addresses, or bank accounts, which may then be relayed to a malicious party without the user's knowledge or consent. Similarly, adware may clandestinely search a user's computing device for sensitive data that can be used for the purpose of delivering targeted advertising. Email messages are highly exposed as they travel across the internet, and hence represent a serious threat to personal privacy. By default, email messages are not encrypted. As such, email privacy can be compromised at any point while an email message is in transit. Although the name and email address of the sender of an email message can be easily forged, the IP and MAC addresses of the source are contained in the packet stream, thus limiting email anonymity. Because of this, a user who wishes to send an email message anonymously can do so by using a remailer. The remailer process is quite simple and begins when a user sends an email message to a remailer server, along with the email address of the intended recipient. The remailer server then removes all information from the message which could identify the true sender and replaces that information with its own identifying details. The message is then sent to the recipient with the remailer server acting as the sender, thus protecting the identity of the true sender. Threats to email privacy include both email interception and email monitoring. With respect to the interception of email messages, just like other internet traffic, email messages can be intercepted while in transit over a network. Because most email messages are sent in an unencrypted format, they are particularly susceptible to interception. As a basis of comparison, consider that with traditional postal mail, an envelope that has been tampered with can provide some evidence of interception. Unencrypted email messages have no such inbuilt protection. With respect to the monitoring of email messages, legal mechanisms allow government organizations and companies to monitor all email messages sent by their employees without exception. Internet service providers and email providers are also allowed to scan and monitor the content of email messages for legitimate business purposes, such as detecting spam or using the contents of email messages for targeted advertising. As such, you should have virtually no expectation of privacy with respect to sending or receiving email messages. The rapid development and adoption of new information and communication technologies implies a need to evaluate and consider those technologies from a privacy perspective. It is not typically anything intrinsic about a particular new technology that raises privacy concerns. Rather, it is how a technology is used and applied that reflects its privacy implications. Some emerging technologies with potentially serious privacy implications include radio frequency identification, or RFID tags, voice over IP, electronic voting, and location-based services. RFID tags are small, inexpensive devices, each of which is uniquely identifiable from a distance. Although RFID tags have obvious benefits for inventory management, supply chain operations, and production processes, they also have serious privacy implications. Consider, for example, that all driver's licenses and credit cards may soon contain embedded RFID tags. Since these tags can be scanned remotely and secretly, a widespread sensor network would allow governments or organizations to track and monitor individuals' movements and activities without their knowledge or consent. Voice over IP, or VoIP, technologies allow for synchronous spoken communications across Internet protocol-based networks. As with other forms of IP-based traffic, voice conversations transmitted over the Internet or other networks are susceptible to interception. Even if the voice data themselves are highly encrypted, the nature of packet-based communications means that the parties to the conversation can be identified via IP or MAC addresses, which, of course, is a threat to privacy in and of itself. Note that the United States government has been revealed to be engaging in both of these activities on a massive scale. The proliferation of ICTs has engendered a great deal of interest in the possibility of electronic voting. Considering the many ways in which computing devices and networks are insecure, societies must carefully consider whether they should trust a process as important as voting to these insecure technologies. Further, citizens must consider whether it would be possible to guarantee that internet service providers and other telecommunications companies would not be able to interfere with an electronic voting process. The adoption of electronic voting would also introduce the possibility of enterprising citizens selling their votes, or foreign governments seeking to interfere with the electronic voting process. Finally, location-based services also represent an emerging threat to personal privacy. Smartphones and other mobile devices commonly include GPS capabilities which allow their locations to be pinpointed with a high degree of accuracy. Savvy software developers can easily write mobile apps that tie into a smartphone's GPS capabilities, thus allowing them to track the user's location. Consider some of the ways in which this technology could be abused. Law enforcement agencies, for example, might track the movements of peaceful protesters. Similarly, lawyers might seek to use this technology to track spouses suspected of marital infidelity. Further, health insurance companies might adjust a person's insurance rates based on how often she visits fast food restaurants, while car insurance companies might adjust her rates based on how often she exceeds the speed limit while driving. Clearly, location-based services are an emerging technology that represents a very serious threat to personal privacy. Well, my friends, thus ends our overview of information privacy, and more broadly, our entire 12-part series of lessons on information privacy and security. It has indeed been a great privilege to have served as your guide on this journey, and I sincerely hope that you learned many new and interesting things about information privacy and security along the way. I also hope that our paths will cross again at some point in the future. But until then, keep learning and have a great day.